Greetings and welcome to the Steel City and Conemaugh Valley Law Advocate, a podcast brought to you by Jason Tetlow and Tetlow Law PC. In this podcast, we'll be talking about various aspects of personal injury and medical malpractice law. Jason Tetlow is bringing over 20 years of legal experience to this podcast, and he'll be sharing insight from his own practices to help you get a better understanding of your case and how he can help you win. In this brief introductory trailer to the podcast, we want to share a few clips from Season 1, so you can get a sneak preview of what you'll experience here on the Steel City and Conemaugh Valley Law Advocate. Before we get to those clips, here's a brief disclaimer from your host, Jason Tetlow.
Hi, I'm Jason Tetlow, the founder of the law firm Tetlow Law PC. Welcome to the Steel City and Conemaugh Valley Law Advocate podcast. I've been helping clients with personal injury and medical malpractice claims since 2001. I created this podcast to provide an overview of the personal injury and medical malpractice processes and answer the questions I most often get when I first meet with prospective clients. My goal is to fight for my clients so they are fairly compensated when they are the victims of negligent actions or malpractice. If you need representation or just have questions, don't hesitate to contact me at 412-248-9600 or visit our firm website at www.tetlowlaw.com. That's TETLOWLAW.com. Any information provided in this podcast should not be taken or relied upon as legal advice. You should always consult with an attorney about the particular facts and issues of your case.
Can we turn our attention for a minute to damages? Can you describe, because I think sometimes people might have all those other three pieces, but not the fourth, or enough of the fourth that says, hey, this is worth you hiring a lawyer or me to do this. So can you talk about personal injury damages a little bit?
I always like to use the word harm. Has somebody been harmed, from an accident? I've certainly seen circumstances, you might understand this, where somebody is involved in a very serious accident and the car flips over and the car looks like it's, the car's totaled and it's a mess. But people walk away with either no injuries, no harm at all, or very minor injuries. And, we're in 2025, so cars are built a lot better, they're a lot safer. There's all kinds of federal regulations that car manufacturers have to adhere to, and which is a good thing, right? Because, today's day and age, cars are just generally safer. So, maybe you don't see as many of the serious injuries from car accidents. It does happen, but that's happens in cases where there's an accident, there's a negligent act, somebody's texting and they're not paying attention and they cause a collision, and the person on the other end can walk away completely unharmed.
There's another term that's thrown out there sometimes called reckless or recklessness. So we have negligence, but there's also the term recklessness. Can you give us an example or define what the differences are between the two, or are there any differences? What does that potentially mean if something's found to be reckless?
When you get into the recklessness of an accident or collision or any kind of incident, generally speaking, that rises then to the level of like a punitive damage type case. So some examples of that might be, there's certain laws out now and there's certain cases that have come down from the appellate courts in Pennsylvania regarding the use of telephones, right? Because nowadays, it's happened to me many times. It happens almost daily. And I'm guilty of it. You sit at a red light and what do? You start looking at your phone sometimes. But the problem is whenever people are driving, texting, looking at their phone, and they cause an accident. So that could be reckless conduct. And I like to tell juries this, when I try cases, I don't just meet with somebody and run over to the courthouse and file a lawsuit the next day. It doesn't work that way. And it doesn't work that way because the law dictates that we hire experts, that we have to have experts. So it's only until an expert tells me it's a case do we then take the next step to file a lawsuit. and then proceed through the court system. And I think, that law has been in place now for over 20 years. It actually, the rule of law is really what's called the certificate of merit. And what we have to do as the lawyer involved in a medical negligence, medical malpractice case is we have to file with the court at the time we file a complaint, what's called a certificate of merit. That certifies with the court that we have retained those experts. That the expert has told us that not only is there negligence or a breach in the standard of care, but there's that causation element, that the negligence has caused harm. So I like to tell juries that because they understand then that it's a process we have to go through, because it adds credibility to our case.
And just to give an idea, is a mediation a day, 2 days, a week, compared to, potentially an arbitration, a trial? What's the sort of time commitment? And just give the listeners a visual of what this looks like.
A mediation is typically a day, and sometimes it's half a day. My recent experience with a mediation, it lasted, I want to say 4 hours. It was half a day, and we were able to get the case resolved. And again, case specific, it just depends upon the attorneys, the insurance representative on the other side, the parties involved. A mediation typically never goes more than a day. You know at the end of the day whether the case is going to get resolved or not. So, sometimes it might sometimes the mediator might stay involved and work with the lawyers to try to get the case resolved after a full day. But no, it's not like a week long. Or the nice thing about mediation, it's not as much. I think the right terminology would be is it's not as involved or emotional for the client. It's a lot when you're sitting in a courtroom and you're in front of the jury. That's a lot different than being at a mediation where it's not. Although it's an adversarial process, it's the mediator that's handling everything. Right? So the mediator is not there to be adverse to your client's position.
Thank you for taking a few moments to check out the Steel City and Conemaugh Valley Law Advocate. We're here to bring you the very best in legal insight regarding personal injury and medical malpractice law. To learn more about how Jason Tetlow can assist you with your case, visit tetlowlaw.com today. Find the link in the show notes. Thank you very much for dropping by today, and we'll see you on the next episode.